it's your girl, Simply Anna, and I'm back with another one. I would ask you to first consider subscribing to my channel, liking this video, and placing a comment down below. Okay, so as promised, I am back with another one to talk about the motion that Nature Boy's attorney, Steffi Yellen, his new public defender, filed with the clerk's office on Thursday. The first thing I'm going to ask everyone who watches this video, if you would please do me a favor, go over to Instagram and follow the Instagram page, Official Kirby Jr., because guys, simply, I would not have been able to put this video together without his help. Attny Kirby Clements is a high-profile attorney in the Georgia area. He's actually based out of Atlanta. He's recently started this Instagram page and gives a lot of really good advice from a criminal defense attorney's perspective. And I think you'll find it extremely informative. Not only that, you guys, I would not have been able to do this video without him because I simply would not have been able to do the research to make sure that I'm giving you guys all correct information, which means I probably just wouldn't have put it out because it would have just been simply too much for me. I'm going to also put a link in the description to his Instagram page. If you can just click on it and follow, that would be great. Thank you. Okay, now getting into this motion. I'm going to go ahead and post the motion on my community wall. But I'll go ahead and address each of the motions and bring in Kirby to explain them. Okay, so 3, 4, and 5 are all around discovery and reciprocal discovery. And Kirby is going to give a brief explanation here about how it works in Georgia.
This is just a general discovery request. In Georgia, if you want to participate in the reciprocal discovery provisions, that is where the state has to give you certain things beyond just a list of witnesses, but instead give you statements of witnesses, actual scientific reports, and things of that nature, you have to elect to proceed under the discovery statute. The defense is then required to produce certain things to the state. It's a reciprocal discovery statute. That's the only way you can get discovery in Georgia. So it's an opt-in state. So it appears that they have opted in. In addition, they have they're objecting to the state introducing any, certified crime lab reports or anything, and which the law specifies can come in without a witness testifying. They're objecting to that, and that they want the state to bring those witnesses in. And then finally, they are objecting to I'm looking for the other piece here. There was another provision. The state is also being told to produce any exculpatory information, and the defense is objecting to any victims being present in any pretrial evidentiary hearing. Like, we're going to call the victims in to be present at this hearing or that hearing, and the defense is objecting to the witnesses being allowed to sit in those hearings because they might hear evidence or the like. Whereas when you're doing a trial, you can ask that the witnesses be sequestered by invoking the rule of sequestration. And if you do that, then the witnesses can't be in court when testimony is happening, and they can't discuss their testimony amongst each other. They are effectively sequestered. So that's what's happening here. So they're not waiving discovery. They're demanding discovery in this situation. It's pretty standard.
Okay, and then as it relates to Speedy trial, which is number 1, here is Kirby's response.
Also, they are not requesting a statutory speedy trial because they didn't plead the language for a statutory speedy trial, which is under Georgia law. If you demand it, you have to be tried in the term of court or the next succeeding term. Depending on the nature of the offense, you can also get another term. But the bottom line is, if you specifically invoke the state statutory speedy trial statute, or you plead the language that says that the defendant shall be tried or discharged, you got to put that kind of language that says you are putting them on notice of the state statutory speedy trial demand, Then, if you're not tried, you will win your case by default because you will be acquitted by operation of law. But this only invokes the Sixth Amendment here and just simply says they demand a speedy and public trial pursuant to the Sixth Amendment of the United States Constitution, and not the state statutory speedy trial. So it would only be analyzed under the Sixth Amendment standard, which is far more lenient toward the state. But it's a good way to preserve those rights in case a case lingers on and the court says, well, did you demand a trial? And you can say, yeah, I demanded a trial. And I said I wanted it to be speedy under the Sixth Amendment. And then this can have implications, down the line if this case lingers on for a few years.
Thank you, Kirby. And don't forget to go and subscribe to Kirby on official Kirby Jr. Instagram. And until the next time, I'll see you guys. You guys stay blessed.